11:47 on a Friday in September. The porch light has been off for 18 months, and Everett Caldwell has not turned it on, because he cannot look at it without seeing the space where Carla used to sit when he brought the bourbon out after a difficult opinion. Tonight, the dark suited him better. A bench memo lay open across his lap, a civil rights case his clerk had flagged for the docket calendar in October, the kind of thing he would usually have finished by 9, but tonight had let slide into the late hours while the jazz played low from the outdoor speakers and the first drink became the second, and the quiet of the street held its shape around him like a room. He did not hear the cruiser until it was at the curb. No lights, no radio chatter, just the sedan rolling to a stop, and then the engine off and a man in uniform stepping out without the usual apparatus of arrival. No identification called ahead. No police officer on scene through dispatch. No greeting when his shoes hit the concrete. The uniform said, Sayers Creek Police. The man wearing it was 33, maybe 34, with the kind of face that looked like it had decided something about the world and was not going to change its mind. You live here? His voice was not a question the way most questions were questions. It was a statement of suspicion edited to sound like an inquiry. Caldwell set the bench memo on the side table, the bourbon he kept in his hand. 14 years as a federal judge had taught him that small courtesies, the ones that cost nothing, were often the ones that made clear who was running the encounter. I own this property, he said. Not defensive, not apologetic, factual. Need to see some ID. For what reason? The officer's jaw tightened at the question. His name tag read Pruitt. Noise complaint from neighbors. He waited. He did not move. He did not explain further. And the refusal to explain was itself a small assertion of power. Caldwell stood. He had not planned to move quickly. But the officer had asked for identification, and the reasonable response was to retrieve it. He went inside the house and left the door open behind him, not a welcome, not an invitation, simply the leaving of it open so he could hear what was happening on the porch while he was gone. The hallway smelled the way it always did, the coffee from this morning and the old wood of the stairs and something underneath that he had stopped trying to name. The judicial identification was in his wallet on the entry table where he always left it. He kept it in the back pocket, behind the driver's license, because he disliked the weight of it in the front. The card itself was solid white government issue stock with his photograph and the federal seal and the words United States District Court, Eastern District of Harlan, printed across the top in the same serif font used on every court order he had ever signed. He pulled the wallet out and walked back to the door. He stepped back onto the porch and extended the card. Everett Caldwell, Judge, Eastern District Federal. Pruitt took it. His fingers held the card by the edges, the way someone holds something they suspect might be evidence. He read it. The information was there for him to read. The title, the district, the federal seal, the photograph that looked like Caldwell because it was Caldwell. Taken 4 years ago when the card was issued. 11 seconds passed. Caldwell watched the officer read a card that told him exactly who was standing on this porch and why he was not required to answer questions about noise on his own property. He watched the officer read it and understand it and keep holding it anyway. Then Pruitt handed the card back. I got a complaint about loud music. Late hour. The music is on my property at a reasonable volume. It's not disturbing my neighbors. Your neighbors disagree. Then they're not actually my neighbors, Caldwell said. He did not raise his voice. He simply stated the logic of it. Neighbors generally know who they're neighbor to. What happened next was the kind of small escalation that looks like nothing if you are not trained to watch for it. Pruitt did not step back. He stepped forward, not toward Caldwell, precisely. There was not any physical contact or any threat of it, but across the property line onto the porch steps without being invited. The way someone steps into a space, they believe they own the authority to enter. His hand went to his belt. The volume of his voice did not change, but the weight of it did. "I need you to stay calm here." Caldwell heard the statement for what it was, not a direction, but a preemptive frame. If Caldwell objected to this officer stepping uninvited onto his own porch, if Caldwell declined to submit to the authority this officer was asserting, then Caldwell would be read as the one who was not calm, the one who was becoming a problem. "You need to step back off my porch," Caldwell said. His voice stayed level. His hand did not move. The bourbon was still in his right hand, and he kept it there because putting it down would look like he was preparing for a physical confrontation, and leaving it would look like he was unconcerned. And either way, the officer would read it as he needed to read it. "This is my property. You can stand at the bottom of the steps and speak to me from there. Or you can leave. I'm investigating a noise complaint." Then investigate it from the curb. Pruitt did not move for a moment. He was calculating something, whether the insistence of his authority could override the simple fact that he had no warrant, no permission to be on this particular porch, and no legal basis to escalate the encounter. The calculation took 5 seconds. Then he stepped back. But the power of the encounter had shifted in a way that made clear to Pruitt that it was shifting away from him. A man who would refuse his presence on a porch, calmly and without apology, was not the kind of man who could be managed through the usual small escalations. So Pruitt did what people do when the standard tools of authority are not working. He reached for a different one. "What's your name again?" "Judge Caldwell." "No, I mean your actual name." Caldwell did not answer for a moment. He understood what was happening. The officer had read a federal identification card with a name printed on it, and a photograph, and a title. And the officer had decided that none of that was relevant to the actual question, which was what kind of answer he could provoke if he rephrased the question in a particular way. The street behind them was empty. The neighbors whose complaint had supposedly drawn the cruiser here were not on their porches, were not watching. The encounter belonged to this porch and this moment, and whatever Pruitt chose to do with it. "Everett Caldwell, Judge, Federal Court." "You know what I think?" Pruitt's voice had changed. It was still controlled, but it had lost the performative patience that had characterized the earlier part of the encounter. "I think you're a nigger on this porch acting like you own it, and that's what your neighbors are tired of." It was spoken once, not shouted, not edited for volume or emotional inflection. It was delivered with the same flat tone Pruitt had used for every other sentence, as if he were reading from a script, which in some sense he was. The script written long before Caldwell had stepped back outside. Written the moment the cruiser pulled to the curb and Pruitt had seen a black man alone on a dark porch and decided what that meant. Caldwell stood very still. He did not move his face. He did not lower his voice or raise it. He did not set down the bourbon or grip it tighter. He simply held his own ground the way he had held it when Pruitt stepped onto the porch. And he said the one thing that made clear: he had understood every part of what had just happened and had decided not to be moved by any of it. "You need to leave my property now." Pruitt's hand touched his belt again. And for a moment, the encounter had the feeling of something that could tip into physical confrontation. But there was a camera above the door. The small red indicator was visible in the dark, and it had been recording since 11:47 p.m., and both men knew that it was recording, and Pruitt understood that stepping further into this particular moment was something a camera would see. He took a step back, then another. I'm going to be talking to your neighbors, he said. This isn't over. Leave now. Pruitt walked back to the cruiser. He did not run the lights. He did not seem to be in any particular hurry. He simply got back into the sedan and pulled away from the curb the way he had arrived, without ceremony, without acknowledgement, leaving Caldwell alone on the porch again with the bourbon and the darkness and the 4 minutes and 23 seconds of footage that the doorbell camera had collected from the moment the cruiser pulled to the curb until this moment now. Caldwell looked up at the camera. The red light was steady. He had glanced at it once during the encounter and had not glanced at it again. But he looked at it now, and he understood that what had just happened on this porch was going to survive the evening. It was going to survive Pruitt's exit. It was going to be seen and examined and entered into records that would outlast both of them. He set down the bourbon. He went inside. He did not turn on the porch light. Monday morning at 6:47 a.m. Everett Caldwell did not call the Sayers Creek Police Department. He did not call the police chief or the city attorney or the union representative who would inevitably become involved if he let the incident exist only as a complaint lodged through the department's own internal apparatus. He called Amara Osei at her apartment 3 blocks from the courthouse, and when she answered on the second ring, awake, alert, the kind of professional who expected calls before 7, he said, I need you to start pulling my case law. Every opinion I've authored on 18 U.S. B.C. 242. I'm flagging potential recusals, so it needs to be clean. But I need it before noon today. Amara did not ask questions. She had been Caldwell's chief law clerk for 4 years, and she understood the register of that request well enough. It was not about potential recusals. It was about building a framework before anyone knew he was building it. How far back? She asked. All of it. Every 242 ruling since I took the bench. And pull the ones I cited in my concurrences on the appellate panels, too. Everything on willfulness. I'll have it by 10, Amara said, and the line went quiet. Caldwell had been awake since 4 in the morning. He had not slept. He had spent the early hours reviewing the doorbell footage again, the same 4 minutes and 23 seconds, played back frame by frame on his laptop at the kitchen table, and understanding precisely what he had captured and precisely what it meant. The footage was clean. The audio was clear. The timestamp was visible on both the video and the metadata. The word was audible. The badge number on Pruitt's uniform was legible enough that a competent person with the will to do so could cross-reference it against the department's roster and match it to a specific officer with a specific 7-year service record and a specific prior complaint history that Caldwell did not yet have, but would have. He had not called the police chief because calling the police chief meant inserting his complaint into a system designed to absorb complaints. He knew how that system worked. He had presided over enough suppression hearings and qualified immunity cases to understand the machinery, the internal affairs investigation lasting 60 to 90 days. The union representative present at every stage. The predisposition toward exoneration because the department and the officer shared a common institutional interest in defending the department's conduct. The complaint would be received. It would be documented. It would be investigated through channels designed to produce a specific outcome. He was going to build a record outside those channels first. At 9:55 a.m., Amara delivered a binder to his chambers. 63 opinions. Every ruling he had authored on Section 242, a statute that made it a federal crime for any person acting under color of state law to willfully deprive any person of any right secured by the Constitution or the laws of the United States. The standard was willfulness. The threshold was knowledge at the time of the act. She had organized them chronologically, cross-referenced by defendant type and by outcome. and highlighted the passages where he had written about what willfulness meant in the context of deprivation of rights. She had also, and this was something he had not asked for, included a separate section with his 5 most significant section, 242 rulings. The ones that had been cited in appellate decisions, that established the precedent he would need if this ever became a federal case. I flagged the ones that addressed the body camera issue, Amara said, in case you need them for the recusal memo. Caldwell understood what she was saying. She understood that the recusal memo was not what this was about, and she was giving him the material he would need to build the case he was actually building. Thank you, he said. Do you want me to keep building? Build everything. Full timeline of the incident, names, times, what we have on video, cross-reference it to the statute, just keep it clinical. No commentary. I'll have it by Wednesday morning, Amara said, and left. At 11:15 a.m. that same Monday, Caldwell filed a Freedom of Information Act request with the Sayers Creek Police Department for the complete personnel file of Officer Derek Pruitt. Service number 4721, including all disciplinary actions, all complaints filed, all letters of reprimand, all use of force incidents, and all body camera footage from his assignments over the preceding 3 years. The request was formal and comprehensive, and it generated an automatic response, confirming receipt and initiating the 30-day statutory clock. By Tuesday evening, Caldwell had filed a formal complaint with the Civilian Review Board, describing the incident in clinical detail, attaching the doorbell footage, and requesting a full investigation into Officer Pruitt's conduct. By Wednesday at noon, he had filed an identical complaint with the Department of Justice Civil Rights Division hotline, the federal intake system that routed police misconduct complaints to the appropriate field office for evaluation. Both complaints were logged, time-stamped, and assigned case numbers that would exist in government databases whether anyone acted on them or not. Thursday morning, 2 business days after the incident, the FOIA response came back faster than expected. A thin manila envelope with a Sayers Creek Police Department letterhead and a cover memo indicating that Officer Derek Pruitt's full personnel file was enclosed per the public records request. Caldwell sat at his desk in chambers and read through it slowly. 7 years of service, 2 commendations, 1 letter of reprimand for excessive force during an arrest in 2019, sustained by Internal Affairs, 14 days suspension without pay, 1 civil suit filed in 2017, settled out of court for $18,000, allegations of racial profiling during a traffic stop, 8 formal complaints filed with the department, 1 in 2019, 1 in 2020, 3 times in 2021, twice in 2022, and once in 2023. Each complaint investigated. Each investigation closed administratively within 60 days. None resulted in sustained findings. The summary was 3 pages, and it was the paper equivalent of a pattern that the department had systematically refused to acknowledge. 11 complaints now, with the Porch incident pending, across 7 years. That was not a lapse in judgment. That was not an officer having a bad day. That was a man who understood that complaints were absorbed by the institution, that investigations were not designed to find misconduct, that the apparatus that was supposed to police the police was instead protecting them. It was a man who had tested the system repeatedly and found it reliable. Caldwell called Amara. How far along are you with the documentary index? I can have a draft by this evening. Do you want me to annotate it against 242? Annotate it against all 11 prior complaints. Map each one to the statutory language. Build the willfulness argument. Don't explain it, just let the pattern speak. That was when Amara understood. This was not going to stay inside the department. This was going federal. She did not say so aloud. She simply said, "I'll prioritize it," and hung up. Caldwell spent Thursday reviewing the 11 complaints. 5 involved alleged racial slurs or racial profiling. 3 involved alleged uses of force against individuals later identified as having no involvement in the incidents that prompted the police contact. 2 involved alleged improper searches. 1 involved an alleged improper arrest. 1 involved an allegation of harassment. In each case, the internal affairs investigation had produced a finding of no sustained misconduct. In each case, the officer had remained on active patrol. In each case, the department had absorbed the complaint and moved on, and the pattern had continued. Friday afternoon, Caldwell was in his chambers reviewing Amara's draft, 12 pages of timeline, cross-reference to specific statutory language, mapping the geometry of each complaint against the definition of willfulness, when his office manager knocked. The police department released a statement. They emailed it to the court as a courtesy. Caldwell took the printed page. The statement was 3 sentences. The Sayers Creek Police Department is aware of an allegation involving Officer Derek Pruitt stemming from a noise complaint response on Friday, September 12th. Officer Pruitt's conduct during this interaction was consistent with the circumstances of the call, and we are reviewing the matter through our standard internal process. We are committed to maintaining the trust of the community and will provide additional updates as the investigation concludes. It was a statement designed to close the door before the door had been opened. It positioned the department's initial assessment that his conduct was consistent with the circumstances, as fact, not allegation. It moved the investigation into the department's own internal process, the one Caldwell had already decided not to trust. It provided no timeline for the conclusion of that process and no commitment to any particular outcome. It was, in other words, the institutional equivalent of Pruitt's hand on his belt, a small assertion of power, a signal that this was being managed, a preemptive stake in the ground. Caldwell printed the statement and carried it downstairs to his kitchen. The bench memo from Friday night was still on the counter, dog-eared now, the margins filled with notes in his own hand. He set the department's statement beside it. He opened a fresh legal pad. He pulled out the pen he used for judicial notes, the same pen he used for bench rulings and oral opinions. A specific fountain pen he had carried for 14 years. And at the top of the first page, in the same hand that had signed 14 years of orders, he wrote, September 12th, 11:47 p.m., Derek Pruitt. That was the beginning of something, not a reaction, not an expression of outrage that would dissolve into the system the way Pruitt had presumably watched other complaints dissolve. He had a copy of the doorbell footage. He had a personnel file showing 11 prior complaints, each one absorbed. He had a pattern that the department had documented and then ignored. He had a statute. He had 14 years of case law in a binder upstairs that mapped the precise legal terrain of what willfulness meant and what proof looked like. He had a chief law clerk who was not measuring her worth by invisibility, but by the architecture of the case she was building. And he had, starting now, a record that would exist independently of what the Sayers Creek Police Department decided to do with it. He looked at the 3 entries on the fresh legal pad. He looked at the department statement. He looked at the binder of opinions. And he understood that he had stopped waiting for the institution to do what it was supposed to do and had started doing it himself. The Internal Affairs Division received the doorbell footage on September 15th, 3 days after the Porch encounter. The department logged it as Exhibit A1 in the Pruitt investigation file. 23 days later, on October 8th, the department released its finding. Officer Pruitt's conduct during the September 12th encounter fell within departmental guidelines given the nature and circumstances of the noise complaint call. During those 23 days, Derek Pruitt remained on active patrol. Caldwell learned the finding through a formal letter on departmental letterhead, delivered to his chambers on a Friday afternoon. The letter was brief and clinical. It thanked him for bringing the matter to the department's attention. It confirmed that an investigation had been conducted. It stated the conclusion. It offered no summary of what the investigation had examined, no discussion of the footage, no acknowledgement that a federal judge's complaint had been treated with any particular seriousness. It was the institutional equivalent of a shrug. A source, no name offered, no on-record attribution, told Caldwell's outside counsel that Pruitt's union representative had made contact with the IA investigator on day 2, not day 1, when the complaint was still being processed. Day 2, when someone with a financial interest in the outcome of the investigation had already inserted themselves into the machinery. Caldwell did not express surprise. He had presided over enough suppression hearings to recognize the institutional temperature. He had sat on the bench while defense attorneys challenged the chain of custody on evidence that suddenly became unclear in police testimony. He had written opinions on qualified immunity that documented the precise mechanisms by which police departments protected officers from civil liability. He understood the machinery. He had simply never watched it operate on himself before. The 23 days moved with the weight of a grinding procedural confirmation. Each day was a day that Pruitt remained on the street, responding to calls, his presence unchanged, his authority unchallenged. Each day was a day the department was signaling that the doorbell footage had been examined and the decision had been made. This was acceptable. This was within guidelines. This was what officers in this department were permitted to do. And the apparatus that was supposed to police that permission was not going to. It was not outrage that Caldwell felt during those days. It was something colder. It was the recognition of someone who had spent a career watching a system from the inside and was now being processed by that system and finding it worked exactly as designed. The design was not to find truth. The design was to absorb complaint and produce exoneration. The design protected the people who wore the uniform and told the people who did not that their version of events, even when captured on video, even when delivered by a federal judge, was secondary to the institution's predisposition to protect its own. Caldwell had a copy of the doorbell footage on his personal laptop. He had watched it dozens of times across those 23 days. The 4 minutes and 23 seconds running on loop in his home office while the IA investigation moved through its predetermined channels somewhere in the police building downtown. He had watched the moment Pruitt's hand touched his judicial identification. He had heard the word again and again, each time with the same flat intonation, the same absence of heat, as if Pruitt were reciting facts rather than violating a federal statute. And he had understood that none of it mattered to the outcome because the outcome had already been decided. On day 23, a Wednesday afternoon, his personal cell phone rang. The number was unfamiliar. He answered it. "Judge Caldwell?" The voice was older, male, hesitant. "My name is James Holloway. I live on your street, 2 houses down from you." Caldwell did not immediately recognize the name. The voice on the phone seemed to be gathering courage to say something. The kind of person who did not want to be involved in this, but had decided, after 2 weeks of internal debate, that he had to be. "I installed a security camera in my front yard about 2 years ago," Holloway said. "After a car break-in, wide-angle lens covers the whole property and out into the street. I've been watching the police department statement about what happened at your house. and I've been watching what they said happened. And sir, what they said happened is not what my camera shows." Caldwell did not interrupt. He let the silence prompt Holloway to continue. "I have 7 minutes and 11 seconds of footage. It starts before that officer even pulls up to your curb. You can see his cruiser at the stop sign, turning onto your street. And you can see him reach up while he's still in the car, before he even gets out, and toggle his body camera off. The light goes dark. You can see it clearly from my angle, from 47 yards out. The wide lens catches the whole thing. The camera goes dark before he exits the vehicle." Caldwell did not speak. "I'm sorry," Holloway said. "I didn't want to be involved in this, but that statement the police put out, it says he was investigating a call. That doesn't look like investigating a call. That looks like someone who didn't want to be recorded," Caldwell said. "You're certain about the timestamp?" "It's in the metadata. 7 minutes and 11 seconds total. The toggle happens at 28 seconds in, well before he approaches your porch." "I need that footage," Caldwell said. "I'll email it to you. I don't know what you need me to do after that, but I'm not comfortable with this being the story that stands." Caldwell gave Holloway his email address. They spoke for another 30 seconds, Holloway offering to provide statements, Caldwell telling him not to contact the police department, to wait for further instruction. Then the call ended. Caldwell set the phone down on his desk. He sat very still for approximately 30 seconds. In his mind, the 23 days of procedural finality inverted. The IA finding had been based on the doorbell footage alone, the incomplete record, the absence of what came before Pruitt exited the vehicle. The finding had been a conclusion drawn from insufficient evidence, which meant it was not really a finding at all. It was a predetermined decision given the appearance of investigation. But if Pruitt had toggled his body camera off before approaching the porch, then the decision to investigate had been preceded by a decision not to record. That was not a lapse in judgment. That was not a miscalibration of authority. That was foreknowledge. Caldwell picked up the phone again and dialed a number he had memorized 3 years ago. The voice that answered on the first ring was Denise Foss, Special Agent, Civil Rights Division, FBI's Eastern Field Office. "Caldwell," he said, "I need to brief you on something." The email from Holloway arrived 19 minutes later. Caldwell opened the file on his office computer and watched the footage. The metadata was precise. The timestamp was visible on the lower corner of the frame. The wide-angle lens captured the entire approach, the cruiser rolling slowly to the curb without lights, the interior visible through the windshield. And then, at precisely 28 seconds into the recording, the moment that changed the nature of the complaint from a credibility contest to a federal case, Pruitt's right hand raised inside the vehicle. The body camera light toggled from green to dark. It was not a malfunction. The device was functioning precisely as it was designed to function. The light did not flicker or fade. It went dark because someone pressed a button to make it dark. Pruitt had read the identification. Caldwell was certain now. Pruitt had seen United States District Court printed on a federal ID, had understood what that meant, and had decided in the interior of that cruiser that he did not want the next 4 minutes recorded. The IA finding had not examined this detail because the IA investigator had not had access to it. The doorbell footage began when Pruitt exited the vehicle, too late to show the toggle, too late to show the decision. The IA investigation had been conducted on an incomplete evidentiary record, which meant it was not an investigation at all. It was a performance of investigation using only the material that had been made available. Caldwell had a second copy of the footage now. He saved it to a separate drive and encrypted it. He forwarded the original to Denise Foss with a single line. This changes the statute. Foss called back within 6 minutes. Where did this come from? A neighbor's security camera. He's willing to testify about the metadata. The toggle is visible to the naked eye? Yes. This is premeditated deprivation, Foss said. She was not asking. She was stating what the footage showed, the sequence that turned a momentary lapse into a knowing violation of federal law. He read the ID. He understood the circumstances. Then he deactivated the only mechanism that would have recorded his conduct. That's not a bad day. That's willful. I know, Caldwell said. I'm opening a federal file, Foss said. Can you get me everything you have? Timeline, the neighbor's statement, the footage, the IA file, the personnel history. I'll have it to you by morning. The union is going to fight this. Yes, Caldwell said. But the footage is unambiguous. Yes, Caldwell said again. It is. The line went quiet for a moment. Then Foss said, You're thinking federal indictment. Caldwell was not thinking about outcomes yet. He was thinking about the geometry of the moment on the porch, the 28 seconds before Pruitt exited the vehicle. The moment Pruitt understood who was sitting on that porch and what that understanding meant, and the choice Pruitt had made in response. That choice was not something the IA investigator could explain away. That choice was not something a union attorney could reframe as a procedural error. That choice was visible on a security camera owned by a neighbor who had simply decided that the truth mattered more than the convenience of staying out of it. I'm thinking federal, Caldwell said. Yes. Caldwell sat in his car in the parking structure beneath the Harlan Federal Building on a Tuesday morning in October, and he did not move for 6 minutes. The space was concrete and low-ceilinged, the kind of garage that echoed with the indifference of institutional architecture. Fluorescent lights flickered in a pattern just off rhythm enough to register in the periphery of sight. His hands rested on the steering wheel. The manila folder sat on the passenger seat beside him. The documents inside, organized the way a federal judge organizes evidence, chronologically, cross-referenced, annotated in the margins in his own handwriting. He understood what was about to happen. He was about to walk into a building that was, in its essential structure, identical to the courthouse where he had spent 14 years. But he was not going in as the authority. He was going in as the victim. The word that Pruitt had spoken on his porch was going to be typed into a federal docket, and his name was going to appear in the victim field. He had asked juries to convict based on evidence he had presented. He was about to ask an FBI agent and a federal prosecutor to do the same thing, and the asking was not the same as the ordering. The asking required trust in an institution that he had just watched demonstrate that it would protect its own officer over a federal judge's complaint. But the footage existed. Holloway's camera had recorded the toggle. The pattern was documented. The statutes were clear, and the annotated analysis in the manila folder beside him was the kind of legal work that could not be ignored or absorbed or explained away through union representation and internal affairs investigations. He picked up the folder. He opened the car door. He went in. The meeting was scheduled for 10 a.m. Foss and Kemper were already in the conference room on the 7th floor when Caldwell arrived. Denise Foss was 44, had spent 16 years in civil rights investigations, and had testified before Caldwell in a police misconduct case 3 years prior with the kind of precision that had impressed him. She did not overstate the evidence. She did not editorialize. She let the facts speak for themselves. Nathan Kemper was 41, an assistant United States attorney for the Eastern District, competent and careful, the kind of prosecutor who built cases that would survive appellate scrutiny. Both of them stood when Caldwell entered. The kind of automatic deference that made clear they understood they were meeting with a sitting federal judge, not a complainant who happened to be a judge. Caldwell set the manila folder on the table and did not sit. "Before you say anything," he said, "I need you to understand what this is." He opened the folder and laid out the first document, a chronological list of Pruitt's 11 prior complaints. But beside each complaint, Caldwell had written an annotation. He had cross-referenced each complaint to a specific section 242 ruling he had authored from the bench. And next to each ruling, in the same precise hand he used for judicial opinions, he had written the legal standard for willfulness that he had applied in that case. The page was a map. It was a map from a personnel file to a federal statute. It was a map written in the language of the court that would ultimately hear the case. Foss started to speak, the careful prelude to a conversation about burden of proof and evidentiary standards, and the difficulty of securing a conviction in a federal case. Caldwell cut her off. "I know what it is," he said. "It's the legal spine of a Section 242 referral. Use it." He laid the second document on top of the first. This one was a handwritten account of the September 12th encounter. It was dated and time-stamped to the second. In the same format he used for judicial notes, the same format used to memorialize opinions, to create the record that would survive appeal and scrutiny. The account recorded every word Pruitt had spoken, the sequence of each escalation, the moment the judicial identification had been presented, the 11-second hold, the moment the word had been used, the body camera indicator's position as Pruitt had stood on the porch. "This is my contemporaneous memory," Caldwell said, "recorded the way I record testimony, every detail that matters." Kemper read through the pages in silence. Foss read along with him. The room held still for approximately 45 seconds. Then Kemper looked up. "The toggled body camera is on Holloway's footage," Caldwell said. 7 minutes and 11 seconds. The toggle happens at 28 seconds, before he exits the vehicle, before he approaches my porch. Foss leaned back in her chair. She understood what she was looking at. The federal case did not live or die by the doorbell footage alone. Foss and Kemper could have assembled a file using the recordings, the conversations, the audio, the timeline, the visual record. Any competent prosecutor could build a case from video evidence. But the annotated personnel analysis, mapped to case law by the judge who had written that law, converted a pattern of complaints into a statutory argument they could present to a grand jury with absolute confidence. This was not speculation. This was not inference from circumstantial evidence. This was the judge who had defined the legal standard for willfulness in this district, applying that standard to the facts in front of him and placing his conclusions on the table. "The grand jury convenes within 10 days, Foss said. It was not a question. "The grand jury convenes within 10 days, Caldwell agreed. Kemper was still reading the handwritten account. His expression had not changed. But something in the set of his shoulders had shifted. He understood that the case he was about to build was not going to be a close call. The evidence was clean. The legal framework was established. The complainant was a federal judge who understood the statute better than anyone in the room and was not asking for mercy or accommodation. He was providing the architecture that would make the prosecution inevitable. "I'll need to interview Holloway," Foss said. "Full statement on the camera, the metadata, the technical specifications." "He's willing," Caldwell said. "And you understand that you cannot be involved in the prosecutorial phase of this?" It was not a rebuke. It was a statement of law. A judge could not prosecute his own case. The appearance of impropriety alone was disqualifying. "I understand," Caldwell said. "I've drafted the recusal memo. I'll file it today. This case goes to whoever takes the seat after I step back." Foss and Kemper exchanged a look. They were not going to be left alone with this case. They were going to inherit a file that had been constructed with the precision of federal case law, annotated by the judge who understood the statute better than anyone in the room, delivered by someone who had decided that the institution's first instinct to protect its own was not going to be the last word. "We'll move fast," Kemper said. "Good," Caldwell said. He gathered the papers back into the folder. He did not hand the folder over. He set it on the table between them. It was theirs now. It was the government's now. It was the machinery of federal justice now. And it was moving in a direction that could not be stopped or absorbed or explained away through any internal mechanism the Sayers Creek Police Department possessed. "One more thing," Caldwell said as he stood to leave. "Every detail in that account is going to matter. Every word Pruitt used, every moment of escalation, every second that passed between the presentation of the ID and the conduct. That's not for sympathy. That's for the statutory language. That's for the jury. That's for the appellate argument that's going to come after conviction. And it will come, because the union will spend whatever it costs to fight this. But what they won't be able to fight is the clarity of the record." Foss nodded. Kemper was already making notes, his pen moving across a legal pad. The machinery of federal prosecution beginning its work. Caldwell walked back to the parking structure. It was still Tuesday morning in October. The fluorescent lights still flickered in that slightly off-rhythm pattern. But the manila folder was no longer on the passenger seat. The documents were now in a federal file. The grand jury was 10 days away. And somewhere in the architecture of the federal building he had just walked through, the case was beginning to move with the inexorable momentum of institutional machinery that, for once, was running exactly the way it was designed to run. The disciplinary hearing convened on a Monday morning in late November in a conference room on the 4th floor of the municipal building. The room was not designed for confrontation. It had the institutional anonymity of a space that had hosted budget meetings and HR seminars, fluorescent overhead lighting that cast no shadow, a table that seated 12, walls painted in a beige that no one had chosen and everyone had stopped noticing. Derek Pruitt sat on one side of the table. His union attorney sat to his left, a woman in her 50s, with the focused intensity of someone whose hourly rate was being paid by a police union with the resources to fight. On the other side sat Caldwell's counsel, Holloway with his camera specifications in a folder, and the hearing officer, a retired police captain brought in by the city to conduct the investigation. This hearing was not the final forum. Both sides understood that. The Sayers Creek Police Department was positioning it as such, framing it as the institutional mechanism where Pruitt's conduct would be examined fairly and found acceptable, as each of the 10 previous complaints had been examined and found acceptable. But the federal case was already moving. The grand jury was scheduled. This hearing was a race against time, and the union was betting that a sustained finding at the departmental level would insulate Pruitt from federal charges. The bet was based on a miscalculation of what was already in motion. Holloway testified first. He was calm and precise in the way someone is calm and precise when they have decided that the details matter more than comfort. He described the geometry of his security camera's field of view with the accuracy of someone who had spent a career installing electrical systems. He explained the lens angle, the distance from his porch to Caldwell's house, 47 yards. The resolution at that distance, the lighting conditions at the time of recording. Then he described what the camera had captured, the cruiser approaching, the moment before the door opened, the body camera indicator glowing green on Pruitt's chest, Then, at 28 seconds into the recording, the light going dark, Pruitt's attorney did not object during Holloway's testimony. She let him finish. Then both recordings played for the hearing officer. The doorbell footage first. 4 minutes and 23 seconds of Pruitt's voice on Caldwell's porch, clear and audible. The words spoken once with that same flat intonation. The judicial identification visible in Pruitt's hand during the 11-second hold. The moment when Pruitt's fingers held the card while he read it, understood it, and then handed it back and continued speaking. Then Holloway's footage, 7 minutes and 11 seconds, that began with the cruiser rolling to the curb without lights, showed the cab interior through the windshield, and showed the precise moment the body camera indicator transitioned from green to dark before Pruitt's door opened. The hearing officer watched both recordings without expression. When they ended, Pruitt's attorney began her defense. The indicator footage was ambiguous. She argued. The angle made it impossible to determine with certainty whether the light had been toggled off or was simply not visible from Holloway's angle. The audio on the doorbell recording was degraded at the critical moment. The word might have been heard differently in context, might have been misunderstood, might have been provoked by something in Caldwell's tone or demeanor that was not fully captured. The complainant's account was colored by the adversarial nature of the encounter. Any officer would have escalated under the same circumstances. The union was not defending the union was defending the escalation. Then Caldwell's attorney said, "The complainant would like to testify." Pruitt's union attorney stood immediately. "Your Honor, the complainant is a sitting federal judge. Judges do not ordinarily testify in proceedings of this kind. This is a disciplinary matter, not a trial. The footage speaks for itself." Caldwell's attorney had prepared for this. "My client is not appearing today as a judge. He is appearing as the complainant. He is testifying to facts within his own knowledge regarding the encounter." The hearing officer considered this. He looked toward Caldwell. "Do you wish to testify?" Caldwell's attorney had advised against it. She had been clear and thorough in her reasoning. Let the footage carry the hearing. Protect the unimpeachable record for the federal case. Do not give the union an opportunity to cross-examine a sitting federal judge on his own perception and memory. Do not risk any ambiguity that could be used in appellate argument. Caldwell had listened to all of it. He understood the reasoning. It was sound reasoning. It was the kind of reasoning that had served him well in 14 years on the bench. He declined the advice. "I do," Caldwell said. He stood and took the witness chair. The hearing officer administered the oath. Caldwell placed his hand on the Bible and swore to tell the truth. And then he began to speak in the same flat, unhurried register he used for bench rulings, the same cadence, the same complete absence of editorial inflection. On September 12th at 11:47 p.m., Officer Pruitt responded to a noise complaint at my residence. When I presented my judicial identification, I was providing him with definitive information about my ownership of the property and my professional standing. At that moment, Officer Pruitt had knowledge of relevant facts. He knew he was on the property of a federal judge. He knew this because the identification was in his hand. He read it. The metadata on my neighbor's camera establishes that he had already toggled his body camera off before exiting his vehicle, a deliberate act that eliminated the recording mechanism that would have documented his subsequent conduct. That deactivation occurred after he had time to understand the nature of the call, to position himself to respond, and to make a choice about what would and would not be recorded. Caldwell paused. Then he continued, his voice unchanged in volume or pace. 18 U-C. Section 242 makes it a federal crime for any person acting under color of state law to willfully deprive any person of any right secured by the Constitution. The legal standard for willfulness is this: the officer must know the conduct is unlawful at the time he commits it. Knowledge is the key element, and knowledge, in this case, is evidenced by the deliberate deactivation of the body camera before the encounter. An officer who does not believe his conduct is unlawful does not deactivate the mechanism that would record it. He looked directly at the hearing officer. At 11:47 and 40 seconds, Officer Pruitt presented my judicial identification back to me. At 11:47 and 41 seconds, he continued speaking. The identification was presented. The identification was read. The identification was returned. The conduct continued unchanged. That sequence is not a lapse in judgment. That sequence is not a miscommunication. That sequence is not a moment of poor judgment under pressure. Under the statutory language, that sequence is knowing. That sequence is willful. Caldwell quoted the word Pruitt had used. Once, exactly, without inflection. The way a prosecutor quotes evidence, the way a judge quotes testimony in an opinion, not as an expression of shock or injury, but as a documented fact. The hearing officer did not interrupt. Pruitt's union attorney did not object. Caldwell finished his testimony and returned to his seat. The union attorney stood to cross-examine. She began carefully. Judge Caldwell, is it possible that Officer Pruitt's body camera malfunctioned? No, Caldwell said. The metadata establishes that the device was functioning. The light toggled off. A malfunction does not produce a toggle. Is it possible you misunderstood the nature of Officer Pruitt's inquiry? No. He asked if I lived at the property. I told him I owned it. He requested identification. I provided it. And during the 11-second period when he held the identification, 11 seconds, Caldwell said. That is the duration visible on the doorbell camera timestamp. He held my judicial identification for 11 seconds. He read it, then he handed it back. The union attorney had no follow-up questions. She sat down. The hearing officer asked one question. Judge Caldwell, to your knowledge, was there any basis for Officer Pruitt to believe you were not the owner of that property? Caldwell looked at the officer directly. He had my judicial identification in his hand. The hearing officer did not rule from the bench. Judges and hearing officers rarely do. They take the evidence, consider it, and issue findings in writing. But the room understood what had just been constructed in it. It was not ambiguous. It was not a matter of interpretation or credibility contest. A federal judge had testified to a sequence of facts, each one supported by metadata and video evidence, each one pointing to a single conclusion. Pruitt knew who he was standing in front of, knew his conduct was unlawful because he had disabled the recording mechanism that would document it, and had proceeded anyway. Caldwell walked out of the hearing room. He did not wait for a ruling. He did not need to. The federal machinery had already begun its movement. The grand jury was scheduled. The evidence was entered. The legal framework was in place. The hearing had been a performance of institutional process, a final gesture toward fairness, but it was not the deciding moment. The deciding moment had been in a parking structure 2 months earlier. When Caldwell handed a manila folder to an FBI agent and a federal prosecutor, 2 days later, the grand jury returned a 2-count indictment under Section 242, willful deprivation of rights. The charges were straightforward. The evidence was uncontested. Derek Pruitt was charged with federal crimes on his own front porch, in a jurisdiction where a federal judge testified against him, In a room where every element of proof was visible and precise and could not be reframed or absorbed or explained away. The union filed immediate appeals. They argued procedural violations. They challenged the grand jury composition. They sought to suppress Holloway's footage on technical grounds. None of it mattered. The video was clear. The statute was clear. The testimony was clear. The only question remaining was whether Pruitt would accept what had been built against him or fight it through trial and appellate process and watch it hold at every stage. The Sayers Creek Police Department terminated Derek Pruitt on a Tuesday morning in December, 3 weeks before the grand jury indictment was formally handed down. The department moved first, using the disciplinary hearing's impending finding to execute the separation before federal charges could be filed. It was a procedural choice designed to limit exposure, to demonstrate institutional responsiveness, to signal to the public that the department had addressed the problem. The choice accomplished none of those things. Pruitt was separated from the department. The record of his conduct remained. The federal case moved forward unchanged. The city's legal department contacted Caldwell's outside counsel within the week. They were prepared to settle the civil claim without trial. The offer was straightforward: $2.1 million, no admission of liability, no public statement of wrongdoing, just a number and a check and the paperwork required to close the matter. Caldwell's counsel recommended acceptance. It was a strong settlement. It reflected the severity of the conduct, the clarity of the evidence, the certainty of judgment. Caldwell accepted the offer within 2 hours. The check arrived 90 days later, drawn on the city's general fund, signed by a municipal treasurer Caldwell had never met and would never meet. He deposited it into his personal account and, before the transaction had fully cleared, transferred the entire balance to the Harlan Legal Defense Coalition, a non-profit organization dedicated to civil rights litigation on behalf of individuals who could not afford counsel. The transfer was complete within the week. The money was working in other cases before the settlement check had been fully processed by the bank. 8 months after the guilty plea, Derek Pruitt stood in the federal district court before a judge who was not Caldwell, a senior judge from the neighboring circuit, brought in specifically to avoid any appearance of bias or institutional conflict. Pruitt's attorney had exhausted every procedural avenue available under federal rules. The body camera footage was inadmissible under no standard they could construct. Caldwell's annotated brief, to cross-reference to federal precedent, could be challenged but not overcome. The grand jury's decision to indict stood. The evidence at trial would be exactly what it had been before the grand jury. Footage, testimony, the words spoken and recorded, the sequence of knowledge and choice. Pruitt pleaded guilty to 1 count of deprivation of rights under 18 U.S.C. Section 242. The plea agreement bound the sentencing recommendation: 18 months in federal correctional facility, 3 years of supervised release after discharge, and permanent entry in the National Decertification Index. His name would appear in a database maintained by the International Association of Directors of Law Enforcement Standards and Training. The database was used by law enforcement agencies across the country to identify officers with histories of termination for cause. His name would remain there. It could not be removed. It would not expire. Any department that ran a background check on Derek Pruitt would see the entry and know what he had done. 8 months after Pruitt entered federal custody, Caldwell sat on his porch on a Friday night in late spring. The same steps, the same bourbon in the same glass. The case file was closed on the side table beside him, not locked away, not ceremonially destroyed, simply finished and set down. The jazz was off tonight. He had not played it since September. 3 houses down, James Holloway's porch light was on, the way it had been on for months. They had exchanged a nod at the courthouse steps the day Pruitt's plea was entered. Nothing more. That was the correct amount. Caldwell looked up at the doorbell camera above the door. The small red indicator held steady in the dark. It was always on, always recording, always keeping the record the way he had kept records for 14 years, precise, complete, available for scrutiny. The camera had captured the moment. The neighbor's camera had captured the moment before. The federal system had captured everything that followed. The record was unbroken. He looked at the indicator for a moment, then he stood. He reached up and turned on the porch light. It glowed against the spring dark, casting the porch into definition, making the steps visible, announcing to the street that someone was home, that this space was inhabited, that it belonged to him. The light held steady. He went inside.